SJC-13769, Andrea Joy Campbell, Attorney General, versus Mystic Valley Regional Charter School.
Attorney Waters.
May it please the court, my name is Charles Waters, and I represent defendant Mystic Valley Regional Charter School. This case is about whether Massachusetts charter schools are state agencies under the Massachusetts Charter School Statute, and as a result, whether they're subject to the public records law in Massachusetts. Now, this is a matter of first impression in Massachusetts, and Mystic Valley contends that the court should here conclude that charter schools are not state agencies, and the trial court's decision should be remanded, should be reversed and remanded. Now, Mystic Valley wants to start with an acknowledgement that there are very close ties between the Commonwealth and charter schools in Massachusetts. And there's a good reason for that. As the court knows, there are public funds that are associated with funding charter schools. And with public funds funding schools in Massachusetts, it triggers the Anti-Aid Amendment. Now, the Anti-Aid Amendment has certain requirements, and it is clear to me that the legislature, in enacting the charter school statute, was aware of these. For example, the statute specifically says that this is a public school, that charter schools are public schools. The statute specifically and is required to state that the Board of Trustees are public agents and that they supervise and control the charter school. And because there's public money being used, they have the same standards for performance for students and teachers that school district schools have. There's reporting requirements to state agencies like BESI, DESI, the commissioner and state auditor. And there's a threshold question, therefore, for this court, and that is, does a school using public funds in compliance with the Anti-Aid Amendment necessarily mean that that school is a state agency for all purposes?
Can you take a step back and interpret the statute for me for a second? Because I thought your best argument might be a textual one, but are you conceding that it meets the sort of language, division, or authority of the Commonwealth or any political subdivision thereof, or are you saying you're outside of that? Because once I get to that five-part test, you're in real trouble. It quacks like a duck, it waddles like a duck, it paddles like a duck. I mean, I'm just, tell me, do you win because of the statutory language? Because I have trouble understanding this outside of that.
Yes, Your Honor. I think, and I agree with Your Honor, I think that's a very compelling argument, is just looking at the statute itself. And when
it's not a division or authority of the Commonwealth or any political subdivision therein, or of any authority established by the general court to serve a public purpose. It's not, it doesn't meet that?
No, I don't believe it does, Your Honor.
Why not?
Well, I think there's four parts to this, and I'll just quickly go through the four parts. The first one, I think, is an agency of the Commonwealth, and I think that's the real argument here. That's where these factors start weighing in. This is not, these are not entities that are authorities created by the legislature. It's also, so I don't think that's the analysis. I also don't think the others are analysis. I think this boils down to whether it's a political subdivision or an agency of the Commonwealth. And I agree with Your Honor that I think the text of the statute here matters. First of all, it doesn't say anywhere that...
Are there cases, I mean, again, once we get to that five-part test, you're climbing a mountain. But are there cases that say, okay, let's identify, whether this is an authority or a political subdivision. If there's ambiguity, then we get to that, or I'm just trying to get a sense of this, because I don't find your argument on the five-part test at all convincing, nor do I understand why there would be a reason not to hold this type of public school publicly accountable and have transparency, while other public schools, we require that. So to me, this is all that you're left with is sort of a pure textual argument. Go ahead.
Again, I don't disagree with that analysis, Your Honor. And I think a compelling area for this court to look at is what the statute actually says. It doesn't say that it's a state agency. And that's significant because if you continue to read through this statute, it does identify when the legislatures wanted it to be a state agency, it identifies the circumstances when it should be a state agency. For example, Your Honor, although it doesn't say it's a state agency, it does say under 89U, I believe, that it's a state agency for purposes of 268A. So the question is, why would the legislature otherwise include in the statute the times when it is a state agency if broadly it were already a state agency or there was any intent for it to be a state agency?
Can you address the Attorney General's argument that the reason for that carve-out is to distinguish these charter schools for those purposes from municipal agencies?
And that's an argument, and I recognize it. I don't think that's the strongest one. And that's because if it were a state agency to begin with, then put it right up front like they do with the MBTA statute, like they do with the Steamship Authority statutes. It says this is a public instrumentality. This is a state agency. This is a public subdivision. Put it right up front so there's no question. They don't do that. Instead, they have several passages, provisions, where the statute identifies when it is a state agency. And so I'd suggest the more compelling way to see that carve out is to compare it to the fact that the statute doesn't broadly say it's a state agency and has to have a carve out for when it is a state agency.
Counsel, we have here not only the text of the statute, but also a regulation interpreting the statute, correct?
I believe there is a CMR, I think it's 950.
And that has the force of law, correct?
Yes, if it's in conflict with the statute, obviously.
Have you raised an argument that it's in conflict with the statute?
I don't know if in reply, we didn't file a reply brief.
I don't understand your reply brief to make a new argument that the regulation is invalid. And so I think to win, you have to win under both the regulation and the statute. Do you not?
I think if this court determines that this statute was designed by the legislature to have a very unique and innovative balance between public and non-public, and that to the extent the operations of charter schools should be considered in that latter category, the non-public category, I don't think so, Your Honor. I think that
So we should just ignore the regulation interpreting the precise term?
I think if this court decides that the statute, that the legislature did not intend to consider charter school state agencies, that takes precedent, and that the CMRs have to follow suit with the statute, Your Honor.
I think this has already been mentioned, but public schools are subject to the public records law. Is that correct?
Correct, Your Honor.
And is there a particular provision that applies only to them? Or do they fall under the same provision we've been talking about?
Yeah, they would fall under municipalities, which I think is defined under the public document definition of General Laws, Chapter 4, Section 7.
Okay, and we said that. Has anyone else said it, that they're subject to it because they fall under the definition of municipalities?
I'm unclear of your question, Your Honor. I'm sorry.
Have we said that? Is there a case that says that?
No, Your Honor. There's no appellate court case that I know of where it's been challenged. And to be fair, I haven't researched whether it's been challenged that municipalities and the school districts are subject to the public records law, Your Honor.
All right, so,
But municipalities are clearly political subdivisions.
That's my interpretation of this, Your Honor. Also,
In schools, public schools, as a city school or a town school, that it's not much of a difference between that and that's clearly a public. I don't know. It just seems like that's not convincing, right?
well, I understand, and I would respectfully suggest that the court do focus on the other areas where it specifically identified charter schools as being government entities in specific situations. And the question should be, why would the legislature bother to call the charter schools government entities in only very narrow specific situations, which, by the way, did not include the public records statute? Other carve-outs, as I'm calling them, other carve-outs are the charter school employees are considered employees, public employees, under 258, general laws for tort liability purposes, 258, and for collective bargaining purposes.
But once the legislature has said that the Commonwealth charter schools are public schools, then why isn't that enough for them to be treated like every other public school in the Commonwealth apparently is for purposes of the public records law?
Your Honor, I have two answers to that. I believe that it's considered a public school because it receives public funds.
No, it doesn't say that.
I know that's my interpretation of the statute.
Okay, but the statute's not qualified in that way.
I agree.
Okay, so why don't we just, if we just were to accept this, the language of the statute, which says it is a public school, they shall be deemed a public, not even deemed, they shall be a public school. If we just accept that, and we've already determined that public schools are subject to the public records law, why is that not enough?
Because I think these entities were created, these organizations were created by statute in a very unique way, and to interpret it like that would be to read past the unique nature of the statute, which I think was designed to comply with the anti-aid amendment and receive public funds, but yet have this whole separate concept of a non-public organization.
But not for
it's one of the reasons why
purposes of evading the public records law, right? I understand that charter schools were created to be independent in certain ways, to foster innovation in education, and have the ability to do that in a way that the average public school does not. Good, but that doesn't carry you to the argument that they're not subject to the public records law, right? Because compliance with public records law, openness to the public as to the documents that the public government entities are creating has a different fundamental purpose than what you're talking about in terms of the charter schools.
I agree, Your Honor.
So why would we conflate that? It's not contrary to the purposes of the creation of charter schools to also subject this public school to the public records law.
Your Honor, I don't think this is an either-or paradigm. I don't think this is either the charter schools comply with the public records statute or there's all this massive amount of information that the public doesn't have access to. I disagree with that because when you look at the statute—
That's not my argument. I understand your argument is that this information can be garnered elsewhere because there's certain obligations. Is that your argument? That there's certain reporting obligations attendant to being a public school, and that those reports are given to the education department, and that you could go, if you want those records, go there. Don't come to me. That's your argument. But I find that, frankly, less than persuasive. Because you can have all the independence that you want and generate all the innovation that you want and educate children differently. But once you comply with the anti-aid statute and you call yourself a public school and you receive public funds, it just seems to me that your textual argument, which I don't really think is a textual argument, it's more of a, in the spirit of what we were trying to create as legislatures, charter schools, that you can comply with that spirit and still have this entity subject to oversight by the public.
Your Honor, I would say that relating to the public funds, that the statute puts in effect all sorts of reporting requirements to DESE and to BESE and to the state auditors and to the commissioner. And so relating to the public funds, there is that access to public records. Now, relating to the independent operations of the charter schools, the way I read this statute is it's an attempt to protect that operations of the charter school as a non-public concept. And I think it's one of the reasons why it's not in one of the carve-outs. The public records, compliance with public records is not in one of the carve-outs. I also think it's one of the reasons why the statute references 156B. Why else would the statute reference 156B relating to corporations and say that it complies or has the rights as all other entities under 156B, except not in contradiction to the statute, which again is a reference back to the public side of this charter school statute as opposed to the non-public side. And Your Honor, I suggest that the non-public side shouldn't be subject to the public records request laws. The public side is and should be through actual state agencies like DESE and BESE.
I'm confused. Why? Why? Just give me one reason why, besides you're saying it's not public, but why? It's a public school. Why wouldn't the parents have the right to file public records requests? I just don't, give me a reason why the legislature would want this not to be allowed.
I think two reasons, Your Honor. I think first and foremost, I think the legislature respected the fact that the school should operate as a non-public organization, which means that it doesn't have the same burdens as public organizations have.
But it's a public school. So
I understand that, Your Honor. I'm just trying to
it's not, I mean, it's not a religious school. We understand why religious schools are not subject to these kinds of risks, nor is it a private school, which doesn't get public funds. It's public in almost every respect, except for what Justice Wendell said, this ability to have more innovation and creativity.
The statute sets forth, Your Honor, a relatively significant obligation for charter schools to keep, collect, maintain, and report a massive amount of information to these state agencies. I could only gather that reporting requirement satisfied the legislature's interest in compliance with public records statutes, that they didn't want to then additionally burden charter schools who already have this burden to have the additional burden to set up a structure for fielding public records requests, Your Honor.
Do public schools have the same reporting requirements to DESE?
Not all of them, although I have not audited and compared the two different requirements. I believe that charter schools have additional requirements that public don't.
Okay, thank you.
Thank you.
Attorney Kilcoyne.
May it please the court, Carrie Ann Kilcoyne, Assistant Attorney General, on behalf of Attorney General Andrea Joy Campbell. There is no disagreement between the parties.
Can you start with the statute?
Sure.
Help me with the statute, because that's the one thing I have some pause on.
Well,
Where do you fit? Use the exact language too. I don't want you to jump to the test, which is what your brief does. So where do you, what provision should I look at in the statute?
well, first of all, Your Honor, I would suggest that we don't need to choose one of those
Give
in
me one.
the
Pick
list.
one.
I think there are several, actually, if I have to choose. I think agency,
Well, it's not really an agency.
political subdivision thereof, or
Let me-
any authority.
Let's just go one at a time.
Sure.
So agency, right, that's usually, it has, those are sort of the branches of government, right? I mean, the branches of the executive branch, the parts of the executive branch, right?
Well, none of these terms are defined, Your Honor. There's no sort of definition to any of these terms that are listed. Obviously, we look towards the intent of the legislature. The purpose of the public records law is to give broad public access.
But when we read all the statutes of the Commonwealth, department, we have the Department of Public Services. Boards, we have all kinds of boards. Authorities, we have the MBTA, the Massachusetts Port. I mean, there are things that sort of fit nicely in those.
There are certainly things that fit very nicely into those. Although, again, I know you suggested not getting to the five-factor test, but
I concede that you win easily on the five-factor test. I'm just trying to figure out whether I have to get you into a category before you do that.
I would say we don't, and for this specific reason, Your Honor, is that as this court has recognized, Mystic Valley Regional Charter School is considered a public school. That is right in General Law, Chapter 7189C. This court in Champa versus Weston Public Schools has specifically stated that records of public schools qualify as public records.
Again, but it doesn't tell me. So I guess you're saying you fit within the political subdivision because a public school is a political subdivision. Again, just.
It could be, it certainly could be that.
Is that the best fit, or what fit is better than that?
Well, I also, any authority established by the general court to serve a public purpose. The legislature specifically established.
Usually that's the Massachusetts Port Authority. There are things that fit into that neatly. A school is not generally deemed an authority, is it?
Well, again, none of these terms are really defined. And so the legislature specifically enacted Chapter 7189 to require that charter schools serve a public purpose, and that is to educate all the children in the Commonwealth of Massachusetts. So any of those particular terms would be applicable. Again,
And they're the opposite of a political subdivision in certain respect, because the political subdivision, I mean, the school, I understand how a normal public school is a political subdivision of that town, you know.
Political subdivisions seem to be I've seen it defined as a term of art that is generally associated with cities and towns. However, I've also seen it more defined as a subordinate unit of government that's created by the Commonwealth to carry out delegated governmental functions. That would also seem applicable here, since again.
Are there good cases that we can look at that connect schools to subdivisions or authority? You mentioned one case, or maybe he mentioned one case. But what are the best cases that do that for us?
Well, we didn't cite any of those specific cases in our brief. I was looking at where I've seen it defined as a subordinate unit of government created by the Commonwealth to carry out delegated governmental functions. It's a federal case, 555 U.S. 353 from 2009.
That's kind of way afield.
I'm sorry?
It's far afield, right? It's the feds interpreting something. We got nothing in Massachusetts that does this for us.
Well, again, the Massachusetts, there's, again, it's most of the state, the case law in Massachusetts, again, really refers to political subdivision as more of a term of art that is traditionally associated with cities and towns. And other units of local government. Certainly charter schools are more similar to local public schools. In this case, Mystic Valley Regional Charter School is I would suggest, more similar to a regional district school where it
The public
applies.
school case that Justice Wolhogen brought up, that's which case?
That is Champa versus Weston Public Schools, which is 473 Mass 86.
Is there any help from I'm sorry.
No, go ahead.
Is there any, can you help me with Chapter 71's provision that says that Commonwealth charter schools are, I think, body politics? Does that, I don't really know much about that term. Shall be a body politic.
Yes, certainly that.
Do you know where we could go to find some guidance on what that means?
I don't offhand, Your Honor. We cited to that body politic, and the Superior Court certainly referenced that as one of the reasons why the charter school satisfied the factors, because it's a body politic. And if you look to the regulations, the public records regulations, governmental entity is defined as any agency or municipality. It includes a governmental agency that is considered a body politic.
Right, and so I guess this takes us all the way back to Justice Stewart's question about what do we do when there isn't a challenge to the regulations?
Well, the regulations are certainly looked at, for purposes of statutory construction. The regulations, you take it from the plain meaning, the purpose of the enactment, the main object to be accomplished. And again, the purpose of the public records law is to provide this broad public access to records to ensure that public officials are performing and carrying out their duties in a law-abiding and efficient manner. And again, I would just revert back to the fact that Mystic Valley Regional Charter School is considered a public school. It's right in the statute. There's no disagreement. And that the records of public schools, specifically enunciated by this court in Champa, stated that those records qualify as public records.
Can I ask you, what is your best understanding of how the 5-factor tests set forth in the MBTA case initially with respect to the conflicts of the 268A and then applied by this court in the context of public records law, how that relates to the statute, this statute?
Well, the court didn't seem too concerned with the name of the particular entity. So it didn't choose which one of those terms was applicable in the Globe newspaper versus the MBTA Retirement Board case, the second board case, which is the one that applies to the public records law. The court simply employed the 5-factor test. And after
Usually, when we do statutory construction, we are first guided by the words of the statute. So let's just try to do that. And I guess that brings us back to Justice Kafker's question. Are you saying that the charter school is an authority that receives public funds, and that's why they focus? They're called within the public records law under the 5-factor test? I guess I'm also. Well, I don't know if Justice Stewart is confused. I'm a little confused as to the overlay between the 5 factors and these delineated entities.
Well, it seems as if this court used the 5-factor test as a proxy for the terms that were listed. So there wasn't a specific focus on all of those terms. The court simply used the 5 factors almost as, again, as a proxy, as a substitute for all of these terms as a better judgment or understanding of the nature of that particular entity that was at issue in the MBTA board case. And those were very comprehensive factors, and it looked at how it was created and whether it performs an essentially governmental function and whether it receives funds and the extent of control that the government has over it. And after all of that review, it made a decision about whether that particular entity was subject to the public records law.
But isn't Champa sort of assumes it? I mean, it just jumps right over it. And this case, clearly, the MBTA is clearly an authority, right? Or the retirement board, there's no question there. They meet some language in they meet the definitions in the statute. Aren't those easier than this case? I mean, I'm not saying this case is hard either, but it's just different. They kind of don't need to wrestle with this so much in those 2 cases because it's kind of a given. I just looked at Champa. Court doesn't even worry about it. It looks like both parties assume they meet that definition.
Well, it seems if the court was concerned or took into consideration that the MBTA authority naturally fell within the statute, then at the end of the day, it would be subject to the public records law. As you said, Your Honor, it's an authority, it's a retirement board. Those terms are specifically listed in the statute. And yet the conclusion in the case was to review all the
It
factors.
sounds like it may be more restrictive, that they look to the statutory definition, and then they apply the test. But I'm just wondering if you have to get over the first hump.
I don't specifically see it that way, Your Honor, respectfully.
No, that's fair.
Again, we would respectfully request that this court affirm the judgment of the Superior Court and find that Mystic Valley is subject to the public records law. If there are no further
I
questions.
do have a further question.
Sure.
And that is that opposing counsel seems to hinge a lot of his argument on the carve-outs, where in the charter schools are to be treated as a public entity, like a state agency. There's carve-outs for that. I'm wondering what your response is.
Well, for one of the specific carve-outs, specifically with respect to the conflict of interest law, I would suggest that that is simply just clarifying language to explain how charter school employees comply with the conflict of interest law. So they comply
Right, and so
as a
I think
state
his
agency.
argument is there is no similar argument, no similar language in the statute for the public records law.
Well, I will point the court to subsection S, where it says charter schools shall operate in accordance with its charter and the provisions of law regulating other public schools. So that seems to imply that charter schools must also comply with other public laws that apply to regular public schools, and that certainly public schools are subject to the public records law. If there are no further questions, I will rest on my brief.
Thank you.